Good evening to you all. Welcome to another video where we will continue our series of question solving where we were discussing the topic of governor. So in the previous video we had completed up to question number 6. So continuing that series we come to question number 7. Consider the following statement in relation to governor of a state in India. So the first statement says that he must be a citizen of India by birth, must have completed the age of 35 years, he must be eligible to be member of Lok Sabha, and he may be appointed as governor for 2 or more states. So one by one we will come to all the statement. First statement says that he must be a citizen of India by birth. So here the important thing is that this term by birth is not mentioned in the constitution. It means that a person who is not born in India, though he is not born in India, if he has got Indian citizenship, suppose a foreigner get Indian citizenship, there are various ways through which Indian citizenship can be obtained, and that we will study in the chapter of citizenship. Suppose a foreigner get Indian citizenship through naturalization. So this naturalization is a process, is a way of getting Indian citizenship after uh, a person, a foreigner has lived in India for a certain period of time and fulfilled other criteria which are given in the citizenship act. So a naturalized citizen can also contest for the post of governor. So this by birth condition is not there. Only the constitution says that he must be a citizen of India. Whether it is by birth or naturalized, both are eligible to be governor of any state. He must have completed the age of 35 years, so that is there. He must be eligible to be a member of Lok Sabha. So this condition is not in the constitution. So this is not a qualification. This is not a qualification for the post of governor. Though if a person is a member of parliament, that he is a Lok Sabha member or Rajya Sabha member, or he is a part of state legislature, that person, if he or she become governor, then that person has to resign from that post. So that has been written in the constitution. So this condition is not there. He may be appointed as a governor for 2 or more states. So this was a provision which was not in the original constitution, but through the 7th constitutional amendment in 1956 it provided that a person can be appointed as governor for 2 or more states. So this is a fact which you have to remember, that a person can be appointed as governor for 2 or more states, and it was not in the original constitution. It was added by 7th constitutional amendment 1956. So this is a correct option statement, and first statement is wrong, second is correct, and fourth is also correct, and third is wrong. So here the answer comes to 2 and 4. So answer is D. Two and 4 is the correct. So if we talk about some basics about the qualification for the post of governor, so in constitution only, if we talk about particularly of the constitution, then there are only 2 qualifications mentioned in the constitution. First is that he must be a citizen of India. So first qualification is that he must be citizen of India. Second is that he must have completed the age of 35 years. So if someone asks that in constitution uh, what are the qualification given? So only two qualification is are there. That first is he must be citizen of India and he must have completed the age of 35 years. Though through some convention, there are some convention also which are not mentioned in the constitution, but they are followed as a custom. So sir, there are some convention related to the appointment of governor. Remember that these conventions are not mentioned in the constitution. They are followed as a tradition. So first convention is that he should be an outsider. That it means that a person, suppose, is elected as a governor of UP. So that person must not belong to that state where he is appointed, so that he is free from all the local politics. So he does not have any local aspiration. So that is the reason given that him why he must be an outsider. Second condition is that the president is required to consult chief minister. So second convention is that consult chief minister while appointing the governor of that state. So you have to consult, the president has to consult the chief minister of that state where the governor has to be appointed. So these are some convention which has been followed, but at times they are they are not religiously followed. And we will read in the chapter of center state relation that what the Sarkaria Commission and Panchi Commission has given the recommendation with regard to appointment of governor. And this question has been asked in UPSC also, that person should be an outsider. So these are some conditions which are recommendation, in fact we must say. So they are given in the these commission, Sarkaria and Panchi Commission, which are related to the center state relation. So in this way you must remember these minute information like qualification, what are the convention. Convention is not an important part, but you must remember that only two qualifications are given in the constitution, other are only the convention which are at time not followed. So coming to the next question, governor of a state is appointed by. So I told you that governor of a state is appointed by president of India. So and we know that who advise the president on the aid and advice of prime minister and council of minister. So indirectly it is an agent of center, the central government. That is the president, that is the prime minister and council of minister advise the president, and in that process the president appoints the governor of any state. So that is the basic basic information. So coming to the next question, the answer here, the answer is president. Coming to next question, question number 9. Consider the following and select the correct answer by using the code given below. The governor shall take oath or affirmation before entering upon his office. The format of oath or affirmation is given in the third schedule. Is it given in third schedule? The governor shall make and subscribe the oath or affirmation in the presence of Chief Justice of High Court, or in his absence the senior most judge of that court. The process of oath and affirmation is given in the article 159 of Indian Constitution. So these are some of the statement which are regarding the oath of governor. So we will try to cover every aspect of that governor post through this question, and I will try to each cover every details, though there might be some instances where some information may be left behind, but I will try my best. The first statement is says that the governor shall take oath or affirmation before entering upon his office. So that is a correct statement, because before entering or before entering into any constitutional post, there is a oath given. So this is a very general statement. So this statement we can say that it is correct. The format of oath is given in the third schedule. So here this statement checks your factual knowledge, because this third schedule of Indian Constitution talks about the oaths. Though it talks about the oath, but it does not mention the governor of state, because as we know that there are 12 schedules in our Indian Constitution, and this third schedule does not talk about the oath of governor, though it talk about the oath to the MPs, MLAs. For example, it talks about the oath to the union minister, state minister, candidate for the election of parliament and state legislature. It talk about the judges of state high court, that high court and the Supreme Court. It talk about the oath of CAG. So we will read all about this when we once discuss these various schedule of Indian Constitution. But for as of now, you must remember that the governor is not included in the third schedule, though it talk about the oath of various other constitutional posts. So this statement is incorrect. The governor shall make and subscribe oath or affirmation in the presence of Chief Justice of High Court. So that is correct, because as we know that at center the Chief Justice of India helps in taking the oath to the president. In the similar way, the Chief Justice of High Court is responsible for the oath of governor. So if the Chief Justice of High Court is absent, then the senior most judge of that High Court uh, is responsible for the oath ceremony of the governor. So next statement says that the process of oath and affirmation is given in the Article 159. So this is a very factual statement, um, because nobody remember these articles about the oath of governor and various other oath. But without knowing this statement, we will try to go for the answer, like how many statement we can eliminate. The first statement, very general statement, that is true, that that is not known, but it is incorrect. We know this statement is correct. So 1 and 3 are correct. 1 and 3 are correct, but that small information that it is not governor is not mentioned in third schedule, we must know the statement also. So this statement is incorrect. Second statement, if second is known, then we can easily eliminate this A, C and D. So only the correct option is that 1, 3, 4. So here the answer is B. So if you can eliminate 2 or 3 statement, then you can easily derive the answer. Coming to the next question. So in this way we are covering every aspect. We will try to complete whole the chapter of governor through these questions. Coming to next question, which one of the following suggested that the governor should be an eminent person from outside the state and should be detached figure without intense political link and should not have taken part in the politics in the recent past? So when we read the center installation, we will read much more in detail about these recommendation of various commission. These are commission formed for the better cooperation between center and state. So these are some of the commission, like this is also commission for center state relation. This is also, so we will read about this commission, but here the answer is Sarkaria Commission. because Sarkaria Commission recommended uh, some guidelines for the appointment of governor. Sarkaria Commission, which gave it report in 19 which was formed in 1983 but gave it report in 1988. So, some of the recommendation of Sarkaria Commission was that the governor should be eminent person in some walk of life. So he must be eminent person in some walk of life in any field. Second is that that person should be from outside the state where he is appointed as a governor. And third statement is that he must be a detached figure. Uh, Detached figure means that he is not actively engaged in politics, not actively engaged in local politics. So this was the third recommendation regarding the appointment of governor. Fourth recommendation was that he should be a person who has not taken too great part in politics, generally and particularly in the recent past. So that person should be a person who has not taken great part in politics. Great part in politics. So he has not taken great part in the politics. So these are the four recommendations regarding the appointment of governor. First is that he or she must be eminent person. He must be an outsider. He must be a uh, detached figure from the local politics. Should not have actively engaged in local politics. And fourth recommendation is that uh, he has not taken great part in the politics in general and immediately in the recent politics. So these all are the recommendations given by the Sarkaria Commission, and they were reiterated. So they were reinforced further by the Panchi Commission, which was later appointed after the Sarkaria Commission. So these recommendations were first given by the Sarkaria Commission. So this answer is correct. C is the right option. Coming to next question. Who amongst the following administer the oath of office to the governor? So we have discussed about the oath of governor. So when we talk about the oath, I told you that it is the oath is given by the administered by to the governor by the Chief Justice of High Court, and if he is absent, then the senior most judge of High Court. So here the answer is obviously C, Chief Justice of High Court. And do remember that if he is absent, then the senior most judge of High Court. So this is the right option. Coming to next question. Which of one of the following statement about the governor of Indian state is not true? So first statement says that he is appointed by the President of India. So we know that we have discussed at length about the appointment that he is obviously appointed by the President of India. That is correct. He can be governor for more than one state, that we have read. That 7th Constitutional Amendment 1956 provided for the appointment of governor for more than two states. He hold office for a term of 5 years. So we will discuss this, that he hold office for a term of 5 years. He can be removed earlier if the legislature of the concerned state pass a resolution for his removal. So this statement is incorrect, and I will tell you that how this statement is incorrect. So first we will discuss some basic information regarding that office of governor, that for how much time he hold the office and how is he or she is removed. So coming to that basic information. So talking about the term of governor office. Term of governor office. So the term of governor, the governor hold office for a term of 5 years from the date he enter the office. So tenure is 5 years, but the condition is that this term is at the pleasure of president. Pleasure of president means that he or she can be removed by the governor at any time the president want. So he or she is at the pleasure of president. So this 5 year tenure is not fixed. He can be removed. So this pleasure of president simply means that he does not have a fixed tenure of 5 years. He can be removed by the president at any time. So though the constitution provide that he will hold office for a 5 year, but it is at the pleasure of president, and the pleasure of president means that no fixed tenure. President can remove at any time. President can remove any time. And one thing to remember here is that, as I told you, it is at the pleasure of president, and this pleasure of the president cannot be challenged in Supreme Court. It means that it is not legally justifiable. So no judicial review can be done for the that why he is removed, why he or she is removed before 5 years. So no justifiability. And second thing is that there is no ground for removal. No ground for removal. Like in the case of president, it was clearly written in the constitution that the violation of constitution was the ground for the removal of president. But in case of governor, there is no ground for removal, like the vice president. The vice president, for the vice president, there is no ground for removal. Similarly, for the post of governor, there is no ground for removal. So these are the small minute detail which you have to keep in mind. It is at the pleasure, no fixed tenure. It means that it has no fixed tenure. President can remove him anytime, and this pleasure that when he is or she is removed, it cannot be challenged in the Supreme Court or any judicial body, and there are no ground for his removal. That why he or she is removed before 5 years. So no justification has to be given. No ground for removal in the constitution. So these are some mm, small information which you have to keep in mind about the governor removal. And one more thing about the removal, you must remember that about removal is that there have been various instances where um, the government at center, when the government at center has changed, they have removed all the previous governor. Like for example, when the VP Singh became prime minister with the support of BJP in 1989, he removed all the previous governor which were appointed by the Congress. And the same thing happened when in 1991, when election were held, the Congress government headed by PV Narasimha Rao came at center. Then his government removed all the previous governor which were appointed by the VP Singh and the previous Chandrasekhar government. So this was the condition which was prevalent in 1990s. But in a very famous case, VP Singhal versus Union of India in 2010. The Supreme Court, what the Supreme Court said? Supreme Court said that a change in power at center. So change in power at center, that is the central government, cannot be ground to recall governor which were previously appointed by the previous government, and hence such action are judicially reviewable. Means a change in power at the center government does not mean that that government will recall all the previous governor which were appointed by the previous government. And such if such action are taken, then those action are judicially reviewable. Means judicial review is possible of those action. So that was a case, but these are the Supreme Court judgment which are sometime flouted by the central government. So this is all about the term of office of governor. So coming to next question. So in this way we will cover every minute detail regarding the governor. We will try to cover each and every aspect so that you holistically cover the governor and no question is remain unsolved. So this answer is so here the answer is D. He can be removed, so there is no such provision. The president can remove at his own will. So I told you it at the pleasure of president. So this is a incorrect statement. So coming to question number 13. Which one of the following statement is correct? In India, same person cannot be appointed as governor for two or more state at the same time. So this we have studied. This is incorrect statement because 7th constitutional amendment provided for this provision that same person can be appointed for as governor for two or more state. So this is incorrect. Judge of High Court and Supreme Court in India are appointed. High Court in India are appointed by governor of the state, just as the judge of Supreme Court are appointed by the president. So if we have some basic information about the appointment, and then you can easily eliminate this statement that this statement is incorrect, because in case of both state that Supreme Court and the High Court, here the judges are appointed by the president. Governor does not appoint the judges of state High Court, so that is incorrect. So we will discuss it further more in detail in the chapter of High Court and the Supreme Court. So no procedure has been laid down in the Constitution of India for the removal of governor from his post. So there is no specific procedure laid down in the Constitution, because the president can remove him at any time, because it is at the pleasure governor post is at the pleasure of president. So there is no specified procedure like in the case of president or the vice president. So there is no such procedure. So this statement is correct. In the case of UTs, having a legislature set up by chief minister is appointed by lieutenant governor. So you must remember that in the case of UT also, when there is a chief minister, there is state legislature, then there must be chief minister. So the chief minister is appointed by president, lieutenant, not by the lieutenant governor. So president appoint chief minister. So this you must remember in case of UTs, and this similar situation is for example in case of Delhi, in case of Puducherry. In the coming year, the Jammu and Kashmir will also be in the same category where there is a state legislature. So here the chief minister is appointed by the president. So this is incorrect statement. So here the answer is C. Coming to next question. Consider the following statement. Select your answer from the code given below. The governor does not have power to appoint the judge of state high court. So this statement has been taken from the chapter of appointment of state high court. So governor does not have power to appoint, because I told you that president can only appoint the judges of high court and supreme court. He is not a part of state legislature. So if you have some basic information regarding the our parliamentary setup, what is executive, what is legislature, and what are its composition, so you can easily say that he is a part of legislature, because the main task of legislature is to frame laws, and we know that without the assent of governor a bill cannot become an act or law. So obviously there is a role of governor, so he must be a part of legislature. So legislature include governor plus legislative assembly. If there is legislative council also, then legislative council is also included, like in 6 state we have legislative council also. So this is the basic composition of state legislature: governor and both houses of state legislature. But in most state there is only one house, so this statement is incorrect. And I told you why is it incorrect, because governor has a very crucial role in giving assent to the bill, then only they become the law of our country, law of any state. He has the power to nominate some member in the legislative council. So this statement is correct, because 1/6 of member of state legislative council are appointed by governor from various fields like literature, science, social service, art, cooperative movement. So how many domains are there? Literature, science, social service, art, cooperative movement. 1 2 3 4 5. So there are 5 domain. From these field the eminent person are appointed or nominated. In fact we must say they are nominated by the governor, and it is 1/6 of total member of a state legislature. Rest of 5/6 member are appointed in a way which we will discuss in the chapter of state legislature, when we discuss the composition of both houses of the state legislature. So for now you must remember that 1/6 member are governor, appointed by the governor, nominated by the governor. So that is true. He has no judicial power, so this statement is incorrect, because governor has some judicial power, like um he is consulted by the president, consulted by president while appointing judge of concerned high high court. So though the judges are appointed by the president, but the consultation is taken from the governor by the president while appointing the judge of that state, that is high court. So this come under the judicial power, and some other judicial power are that he make appointment and posting promotion of district judges. So in case of district judge, he make appointment, posting, promotion, though it is with consultation of a state high court, but they are appointed by the governor. So this power is also under judicial power. So in this way we can say that the governor has some so so in this way we can say that the governor has some judicial power. So there are other some judicial power, like he also appoint person to the judicial service of the state, like there is an exam for civil judge in the various state. So in that case also he also appoint that person to the judicial service of the state in consultation with the state high court and the state public service commission. So this exam is conducted by state public service commission for the civil judge, and these judges are also appointed by the governor. So these are some of the power, judicial power in fact, which are provided for the governor. So in this way we can deduce the answer that this statement is true. He is not a part of this statement, incorrect. He has power to nominate, this is correct. This is incorrect. So 4 is incorrect. 2 is also incorrect. Only 1 and 3 are the right option. So answer is B. So in this way we are also discussing fundamental of polity, and also trying to solve the question on the basis of our knowledge. So coming to next question. Question number 15. When the same person is appointed as governor of 2 or more states, the emoluments and allowances payable to the governor. So in this particular aspect, there is a provision in the constitution which says that, so in this particular aspect, if we talk of emoluments or allowances of governor, then there are 3 things we must remember. First is that he is entitled to such emoluments and allowances as determined by parliament. So you must remember that they are determined by the parliament, not state legislature. Second thing is that when the same person, suppose the same person is appointed, same person appointed as governor for 2 or more state. So this is a condition where the same person is appointed as the governor for 2 or the more state. Then these emolument and allowances are shared by state, in such a way which are determined by the president. So president determine that how these emoluments or allowances are to be shared by the state. So here there is a role of president, and if he is a governor of only one state, then these emoluments and allowances are determined by the parliament. And third thing is that these emolument and allowances cannot be diminished, so can't be diminished or reduced during his tenure. So these are the 3 things you have to remember regarding these emoluments and allowances. So now you can easily solve this question. When the same person is appointed as this, so it shall be allocated among the state in such a way as president may by order determine. So this is a correct statement. If that person has been a governor of only single state, then it has to be determined by the, I told you, the parliament, not state legislature. So now you can easily solve this question. So that is the correct option, that is D. Coming to next question, which of the following are the discretionary power? So we have earlier discussed about this. Sending a report to the President of India for the imposing President rule. So this is under Article 356, and this is a constitutional discretion. I told you that there are two types of discretion for the post of governor: constitutional and situational. So constitutional means that they are mentioned in the constitution. Appointing the minister, so that is not a discretion, because for the appointment of minister, the chief minister advises the governor, that the CM told the governor that who all those persons are to be appointed as minister. So minister are appointed by the governor on the advice of CM. Reserving bill passed by state legislature for the consideration. So that is a constitutional discretion under Article 200. So this is also discretion. Making rule to conduct. So these rules are not under the discretion. They are made on the aid and advice of CM and COM. So this is incorrect. So correct option is first is correct, third is correct. So the answer here comes to B. B. So B is the right option. Coming to next question. Under the constitutional provision on bill, recommendation of the governor was required, but without recommendation of governor, it was introduced in Rajasthan Legislative Assembly and passed by it, sent to the governor. Now, so what will happen? So though we will read about these various bill, that how they are introduced, what is the procedure, we will read in detail in the chapter of state legislature. But as of now, you must remember that there are certain bill like money bill which are introduced in the legislative assembly only with the prior recommendation, only with prior recommendation of governor. But if that is not followed, like in this question, this rule has not been followed, then what will happen? So generally, when the bill is uh, money bill is introduced, it is with the prior recommendation, and the convention is that generally the governor give assent. Governor give assent. So here it has been not the case. So now where assent to the act was given by the governor shall not be valid. So suppose the governor give the assent to the to that bill. So will it be invalid? No, because it is a convention that governor give assent. So it will not be invalid. So this statement is true. The governor can refuse to the assent on the ground of violation of constitutional provision. The governor will send such bill to assent of president. So that is incorrect. The governor or the president assent it, then the court will declare it unconstitutional. So that is also incorrect. Governor can refuse. Governor do not generally refuse the money bill, because here it is talking about the type of money bill. So the correct option is A. Now coming to the next question, that is the approval of ordinance promulgated by governor is necessary. So after an ordinance is made, or in the political terminology we say that ordinance promulgation. So after it is promulgated by the governor, then whose approval is necessary? So approval of state legislature is necessary for its continuation, because we will shortly I will discuss about the provision of ordinance making power of governor, but state legislature need to pass that ordinance within 6 weeks from reassembly of state legislature. From within 6 weeks from the reassembly of state legislature. So whose approval is necessary? So that is state legislature. Now coming to the ordinance making power of the governor. So we will briefly discuss about its various provision. First of all, you must know that Article 213 deal with the ordinance making power of governor. In the case of president, it was 123. Article 123. So we will draw a comparison between both governor and the president. But first, we will discuss the various provision of the ordinance making power of governor only, because that will confuse. So coming to this governor, so article is 213. So basically, what is the need of ordinance? Why this provision has been given in our constitution? First of all, we should know that what is the reason behind it. So reason behind is that if any unforeseen event or any urgent matter arises in the state, then plus the house, that is state legislature, that is the which comprises of legislative assembly, or in some state we have both legislative council. So suppose the these both houses are in recess, which we say that they are not in session. Not in session. So what will happen? Who will make the law? Because the law making power has been given to state legislature, but there is a urgency. There is urgency to make law. Then who will, in this situation, make the law? So to deal with such situation, this ordinance making power has been given to governor in a state. So that is the basic idea behind ordinance making power. Now discussing it further, is technicalities. So I told you that the task of law making is done by the state legislature. I told you when an state legislature comprises of in some state it consists of both houses, but in most state at large it consists of legislative assembly only. But we will see both situation. This is legislative council. Suppose the house is not in session. Suppose the state which have only one house, that is legislative assembly, the house is not in session. So what will happen? In the state where both houses are there and they are not in session, so what will happen? Then the role of governor comes to make the law. So the governor will promulgate ordinance. But remember, this ordinance making power is on the aid and advice of CM and Council of Minister. It is not a discretionary power of governor. It work only on the aid and advice of the CM and the Council of Minister. So that is one thing you must remember. Now, so this is the first thing you have to remember. I told you that governor on the aid and advice of Council of Minister promulgate ordinances if the governor think that the situation has arisen, but not in his personal discretion. Rather, in practicality, we can say that that the government think that the situation has arisen to make such law. So this and you must remember that this satisfaction of, because this word has been used, satisfaction of governor, because it has been written that he governor can promulgate ordinances only when he is satisfied that the situation exists which make it necessary for him to make ordinance. So this satisfaction is not basically his personal discretion, it is actually a discretion of government, but this satisfaction is under judicial review, because there are situations where the government deliberately make law on the controversial subject, try to pass the law making power of state legislature where there is a discussion about that particular law or any decision. So if the government is trying to deliberately bypass that process, then the judicial review can be done of that satisfaction, that was it really necessary to make that ordinance. So that is one thing you must remember, that the satisfaction of governor, which is in actuality the satisfaction of government, is judicially under review. So judicial review can be done. So that is another thing you must remember. Third thing is that the ordinance making power is of governor is co-extensive with legislative power of state legislature. Co-extensive means that the domain of governor to make ordinance is similar to the domain of law-making power of state legislature. That is, state legislature can make law on the state subject only, state subject plus concurrent subject. So it can't be like that the governor can issue ordinance on a union subject, because the domain of state legislature, which is the domain of state legislature, that is only the domain of ordinance making power of governor. So this is one thing you must remember. So ordinance can only be issued for a state subject and the concurrent subject, and we know that on concurrent subject both parliament and state legislature can make law. So the fourth thing is that suppose an ordinance has been issued, then it must be laid down in house. So it must be laid down in legislative assembly or both houses if there are two houses when it reassemble. It means that uh, when an ordinance has been made, because the state legislature, that the houses were not in session. So suppose when the both houses or one of the houses where it is only one house, so when they reassemble, that ordinance has to be laid down in the houses, that is state legislature, because its approval is necessary for its continuation, because it is not a because this ordinance making power is not a parallel legislation. Law making power is the exclusive domain of state legislature. That was only an emergency power. So it has to be passed in the state legislature. That's why this provision has been made that it has to be laid down in the house when it reassemble. So remember that it is not a parallel power like of a state legislature. This ordinance making power is not a parallel power. So this is one crucial point you must remember. So, and the fifth point is that if we talk of its uh, life of ordinance, time period, that is what will the time period of ordinance. So you must remember that an ordinance issued by the governor, it is it ceased to be operate on expiry of 6 week. Suppose the state legislature after the reassembly does not take any action, does not lay that ordinance in the house, and it is not approved by the state legislature, then it can work only up to 6 week. So that is an important point. But there are situations like this life period can be terminated earlier also. Suppose governor withdraws it before the period, before the completion of 6 week. Suppose the state legislature after reassembly disapprove it. So these are situations where this life of ordinance can be reduced or can be cut within 6 week. But otherwise its maximum duration is 6 week. But if it is passed, then it can continue for the until the state legislature discard that law. So that is another case where the state legislature is has earlier approved it, but after some period it realized that there is no need of such law, then it can discard that law. So that is another provision. And the last point regarding this ordinance power is that governor, in what situation governor in which situation governor cannot issue ordinance without the instruction of president. Instruction from president. So there are some situations where the governor has to first take instruction from the president before making any ordinance, before promulgating any ordinance. So there are some situations like, first is that if the bill, suppose it was not an ordinance, if that bill containing same provision would have required the previous sanction of the president for its introduction. So first situation is that, suppose it must have been a bill requiring previous sanction of president before its introduction in state legislature state legislature. So for instance, one of the instance where it happens is that the bill imposing restriction on freedom of trade and commerce. So we will read about this in the center state relation, that the state legislature has the power to impose restriction on freedom of trade and commerce, which is intrastate plus interstate. So in that situation, if the state government is willing to introduce such bill, then it has to take previous consent of that recommendation of the president. So it is one situation where the governor has to take instruction from the president. Second is that it would have been necessary to reserve a bill of same provision for consideration of president. So I gave you two example in this case, like in the case of when the bill is endangering the position of High Court. Second is that there is a subject which is under a concurrent list. Suppose the state legislature is entering that domain where the law has been already made by the parliament, and the state legislature is also entering that domain. So in that case also, uh, the state legislature, not the state legislature, the governor must reserve that bill and take the previous sanction of the president, like in the case of NEET, which is in recently in news of Tamil Nadu. And third situation is that, and the third situation is that if an act of state legislature containing the same provision would have been invalid. So this is a general statement, like any bill which would have been invalid without receiving president assent. So any bill that would not have become bill if the assent of the president was not given. So in that case also, the in that case also the governor has to consult or take prior permission of the president. So these are the three cases, A, B, C. So this is all about the ordinance making power of governor, and I discuss all the possible situation where he or she can issue ordinance, not issue ordinance, and I told you about the article that is 213. So now you can easily solve 2-3 questions regarding this. So approval of ordinance promulgated by the governor is necessary. So I told you about this. Suppose an ordinance has been promulgated, then I told you that its lifetime is 6 weeks from reassembly. So it has a maximum lifetime of 6 weeks from the reassembly of state legislature. So that bill has to be laid, that ordinance has to be laid down before the state legislature for its continuation. So answer is state legislature. If the government really think that the ordinance was genuine and it need continuation, then it need the approval of state legislature. So that is correct answer. Coming to next question, which among the following article of Indian Constitution empower the governor to issue ordinance? So I told you that article 213. In the case of president it was 123. So in this way you can remember 123 213. Coming to next question, under which article of Constitution of India governor has power to promulgate ordinances? So that is 213. Again same question. This is also a similar question. Ordinance making power under which article? So that is 213. 123 is for the president. So we have completed up to question number 21. So there are very few questions left in this chapter, which I will try to complete in the next video, because they all are easy question. the basic provision or I must say that important provision has been covered, but if anything is left I will try to cover in the next video. So if you like our content, our videos, please do like and subscribe also if you like it, uh, and do comment in the comment section. Thank you and have a nice day.